Okay, wonderful. How's everyone doing? Yeah, it's wonderful to see you all in person. And thanks for tuning in on Zoom for those tuning in on Zoom. This is the first in-person workshop we've done for 3 years. So we're really thrilled to have you all in person and to work with you for the next couple. What?
Go to clap for that.
Okay, so first of all, I know we've done 2 sessions already, but some people maybe haven't been at the last session. So I'm still gonna have everyone do introductions for all of our volunteers.
Awesome.
Oh, so that isn't anything. Go ahead.
Oh, well. Hi, guys. My name is Aaron. I am an alum from Foothill 2019. I was Unit 6 at the time. This is my 2nd year working with CACE, and I'm excited to join the board this year and see how responsibilities that entails. But I'm really excited about this program. I really love the way that this has kind of influenced my college career and how I've gone from just environmental science to environmental policy as well. And I think you can learn a lot from this program no matter what you end up doing.
Hey everyone, I'm Dan, also a board member of CACE.
Yeah, it's like the conch. Hi, my name's Clint Woods. I am a Deputy Attorney General from the state of California, one of the founders of CASE, and I am really excited to see what you guys have to say today.
Oh, I feel like I touched something.
Yeah, you're good.
Hi everyone, my name is Michael Chen. I am an alum of the program from 2016, Unit 6. I now work as a philanthropic consultant at a firm called Redstone Strategy Group and been involved with CASE since 2017. So it's good to be back here and see you all in person.
Everyone, I did? Aaron. Cool. It is red.
Cool.
Yeah.
Oh, no, you're fine. You're fine.
Because it would be a red light or brown.
Got it. Okay. Hi, everyone. My name is Vikram. I am also an alumni of the program. I was in Unit 3 at Foothill in 2012. I was an undergrad at Berkeley, also did my PhD here. And I started a company after grad school, which I now run. So yeah, very excited to hear what you'll have to say.
Hi, good morning, everyone. My name is Sean. I am also
Okay, there you go.
all right. I don't know.
Touch the microphone. It means you're muted.
All right. I don't know what was missed, but anyway, I've been an alum of the program since 2002. I'm an attorney, downtown San Francisco employment law, and I've been volunteering since about 2007. And I do want to give a special shout out to Sabrina, who is our president as of this year. So welcome, Sabrina. She's been doing a really wonderful job keeping this program going and building on past successes of our prior president, Clint. And taking us back to in person this year and just really taking this program or taking our CASE nonprofit in a really great direction. So thank you, Sabrina.
Hi, my name is Sahil, also an alum of the program. I graduated from Amador in 2017.
Okay. All right. So before we get started into the content of today's CACE summer session, I just wanted to give a brief overview of what we've learned in the past 2 sessions. So in the first session, we were giving you sort of the basics of what the We the People program is about and going over sort of, what's the structure of a hearing and getting you sort of set on understanding the different kinds of branches. We had that epic debate about what's the strongest branch. During the second summer session, you learned about classical republicanism and natural rights philosophy, and also learned a little bit more about the rubric that's used in this competition.
Yeah, the audio like staying out quite a bit. Yeah, maybe keep the mic like don't touch anything.
I won't touch it.
All right, can everyone be quiet, please? Harsha, can you hear us now? Can you hear me now? And it's cutting out? I can't. That's okay. It's just,
Okay.
Okay.
Just trying to figure out.
all right, here's your charts.
All right. Checks and balances. Fun, fun, fun. So it sounds like you guys have already learned a little bit about the 3 branches and their individual powers. So I think this should be mostly review. But I mean, can anyone tell me what the point is of having checks and balances? Anyone? Yeah?
One branch doesn't use their power.
Okay, yeah, right, absolutely. Anyone want to add to that? Yeah,
So specific people in branches use their power.
absolutely. Oh, sorry, yeah. The answers that we got so far were, protecting abuses of power from a branch or maybe an individual within a branch. Any other additions to that? Why do we care about protecting abuses of power within a branch or an individual in a branch? Yeah? To prevent tyranny. Okay, what does that actually mean? Right, absolutely, right? So I mean,
What did she say?
oh, sorry. Yeah,
a check where, to pass a bill, it has to go through both houses of Congress. There are even additional limitations on that, like the certain kinds of bills that start in which house, right? For example, revenue raising bills, all your tax bills, those all have to start in the House. Is there anything else anyone wants to add? Yeah? Oh, you haven't spoke.
Yeah, congressional override. I don't think that's.
A congressional override, like of a veto? Yeah, absolutely. Right. Congress can override a veto, right? A veto in and of itself is also a check on Congress. All right, then. I think that's pretty good for checks and balances. Oh, yes, sir.
I think you were saying what's not necessarily on here, and one thing that's not necessarily on here is the ability of the congressional branches to conduct hearings, to send subpoenas, and we've seen a lot of that in the last 3 to 5 years. And investigate the other branches.
Yeah,
particularly the executive branch.
absolutely. We were just talking about the ability of Congress's investigative powers, through holding hearings, their subpoena powers, and how that really forms a check on the executive. Does anyone want to tell me why that's a check on the executive? Sure.
Over any action.
Absolutely. Preventing wrongdoing and serving as kind of, a threat over the actions, of the executive. Congressional hearings, you hear about them all the time on the news, right? In these long investigations, right? I mean, right now we're talking about the January 6th hearings, right? And whatever, action that could be recommended or brought on by them in the future.
And so some of those actions could be passing a law in response.
The mic?
Sure.
No, whenever you-
Yeah, here's that. Passing a law in response to the investigation, or it could be impeachment, as we saw during the Trump administration, or it could just be exposing things to the voters, because voters act as a check on all of our elected representatives, everybody except the U.S. Supreme Court, basically. And they can also refer things to the Department of Justice for prosecution if they have a criminal wrongdoing in this investigation. So again, that puts it back in the executive branch, but those departments are sometimes operating independently of the president.
I think another, large check that wasn't really included on this chart and that we haven't talked about yet has been also, the appointment process in the judiciary, right? So, I mean, we've, you probably heard about, the appointment of Supreme Court justices, right? Where the Senate has to confirm, the justices that the president decides to appoint to the Supreme Court. So, I mean, starting way back with, not way back, that's not that long ago, but kind of with Merrick Garland, at the end of President Obama's term, we kind of started to see a shift and, a new interpretation of the Senate's ability to, confirm justices, where they decided that they can kind of make that into a negative, where they can, actually refuse confirmation or even to hold hearings to do something like that. And, that's a large check on, not only the president, but on the judiciary itself. Anyone want to add anything? Yes, sir.
The check and balances can kind of fall apart if there's not pollution, like it's a strong term, but if there's work, it's like what we saw with like the legislative branch refusing to allow appointments, or even getting partisan people in the judicial branch, people that involve parties that is not a lot of accountability.
All right, so we had a question about, whether or not checks and balances fall apart when, there starts to become a lack of accountability. And I guess my answer on that would be, that depends on your definition of falling apart. I mean, I think a lot of those kind of things end up being intentional, as like a planned thing. I mean, there's no rule to say that you can't do something like that, right? You know, if say, you know, a party has, you know, or a group of people in power have decided, you know, when they occupy many, you know, branches of government that they want to do something, you know, like say refuse appointment of a Supreme Court justice, is that actually falling apart, or is that, you know, a proper exercise of power? I think that's kind of up for debate.
I think it is too. And one thing you're going to hear over the year is that our framers didn't necessarily anticipate political parties. So what we see in the modern system with these political parties sort of operating irrespective of which branch of government they're in, that's not something the framers really anticipated, but they did anticipate factions. They just didn't think it would be quite the way we see it modernly. So there was this idea that, you know, the wealthy, you know, landowners would, you know, have their own self-interest and elect whoever they elected to Congress, and those people would sort of be protected in that faction versus, you know, other factions, farmers, etc. So, you know, there is this idea of factionism that was part of the Constitution. You'll see this in the Federalist Papers as well.
All right, I think that's pretty exhaustive on checks and balances. Any last questions? Cool.
Great. All right, thank you. And apologies to the people tuning in on Zoom. We're still working out the kinks logistically, so hopefully you can hear us now. I asked that if any CACE people want to chime in, that they try and come up to this computer, because this is going to be the source of the sound from here on out. So next up, we're going to have Clint talk about judicial review. So come on up.
All right. Hi, all. Okay. We just heard about checks and balances in general. And if you're at the first summer session, you heard me say over and over and over again that the most powerful check and balance, the most powerful check, was judicial review. So can anybody give me a definition of judicial review? Over there. Okay, so the definition that was given was if Congress passes a law, the Supreme Court or the judiciary system has a chance to review that law to determine the constitutionality of that law. Is that right? Okay. So if Congress passes a law, the judicial system can look at it to determine the constitutionality. Is judicial review limited to reviewing acts of Congress? Seeing some shakes of the head, no. Okay, so let's expand that definition a little bit. It was a very good start. Let's expand it. So can the judicial system review acts of the president, of the executive branch? Yes. Yes. So can the judicial system, the federal judicial system, review acts of the states? Yes. Right? Okay. Is judicial review limited to just the Supreme Court, or can lower courts use the power of judicial review? Which is it? Somebody give me an answer. Is judicial review limited to the Supreme Court? No. Lower courts can use the power of judicial review. Why is the Supreme Court the big deal? Because they get the final say. That's it. That's the only reason. Okay. And they have some original jurisdiction and blah, blah, blah. We're not going to get into that. So let's review our definition. Okay. It's when the judicial system, be it the Supreme Court or the lower courts, review an act of Congress, an act of the executive, or a state law to determine whether those things comport with the Constitution. Everybody have our definition set? Okay, great. Now, what is the first Supreme Court case that everybody thinks of when they think of judicial review? Marbury versus Madison. Okay. Now, what does Marbury versus Madison say? I promise I won't yell at you if you're wrong. What was it? It establishes judicial review. Yes, okay. That is the common thing that everybody says, that Marbury versus Madison, which was in 1803, establishes judicial review. The Constitution was ratified in 1789. So the common thing that people think is that in between 1789 and 1803, there was no such thing as judicial review. And I am here to tell you folks today that that is dead wrong. That is entirely wrong. And there are a few reasons why I will make this argument. One, Federalist 78, which was written by Alexander Hamilton, star of stage and screen. He wrote back in 17, whenever the Federalist Papers were written, he wrote that in Federalist 78, that it is emphatically the duty and the power of the judiciary to determine the constitutionality of laws. That's what he wrote. And folks, I don't know if you remember our definition of judicial review, but it's the same thing. He wrote that back in 1770, whenever it was that he wrote that. I don't know. Then in 1796, the Supreme Court ruled in a case called Hyleton versus the United States. You can look it up, about a carriage tax law that was passed by Congress. And they reviewed it and they said, you know what? It's constitutional. And remember our friend here, and I'm sorry, I don't know your name, said that judicial review was using the power to review laws to determine whether they violated the Constitution or they were consistent with the Constitution. And both of those were consistent with the use of judicial review, right? So Hyleton versus the United States was a use of judicial review. They just said, hey, that law, it's constitutional. So let's go back to Marbury. What did Marbury really do? What was the groundbreaking thing about Marbury? Well, it was the first time that judicial review was used to strike down an act of Congress. It was the first time that the check from the judicial branch was used in order to invalidate a law duly passed by the political branches. And that is important. That is revolutionary. It's not establishing judicial review, because judicial review was intended by the founders. We know that because of Hamilton saying so, and had been used prior to Marbury versus Madison. Now, does that mean that the founders intended judicial review to be used in the way it is being used now? Absolutely not. Under no circumstances. They had no idea that the Supreme Court would become as powerful as it is. In fact, that same Federalist paper, Federalist 78, said Hamilton was saying the judiciary branch is by far the weakest branch. That's what he says. Now, he was selling a bill of goods. He was trying to get people to ratify the Constitution, but he also probably believed that on some level. He was also very wrong. And one of the things that you guys are going to learn throughout this year, and one of the things that I hope that we import upon you, is a respect for the founders, but also an understanding that they were wrong about a lot of stuff. Not just the slavery, not just the, really wild racism and a discrimination against women and minorities and all those sorts of things, but they were just flat wrong about how the government would work. We heard a little bit earlier, a question earlier about how, well, what happens if there is perhaps collusion between the branches? Perhaps. Well, folks, one might make a really strong argument that there has been collusion between the branches on a party system. And there is also, as Sean mentioned earlier, a lot of people who would argue that the founders did not and could not have anticipated how the party system would work. Well, there's a lot of scholarship on the other side that they should have known that political parties did exist at that time. Of course, they weren't necessarily as powerful as they are now. But so that's the sort of overview of judicial review, that it was how it was brought up. It has been used in ways that all of you can probably imagine. What are some, forgetting about like the last couple of, say, months. Let's forget about the last couple of months, please. What are some really important cases where the Supreme Court or lower courts have used judicial review for good or bad? Over here. Dred Scott v. Sanford. They started the Civil War. Bad, probably bad. Over here. Brown versus Board of Education. Better. Reverse Plessy versus Ferguson. Integrated the schools, or at least tried to. Behind. Oh, Oh, okay. Took Brown. Okay. Anybody else over here? Roe v. Wade established personal right to abortion over here. Obergefell v. Hodges. These are all ways in which those last two cases are times when the Supreme Court used judicial review to strike down a state law that in doing so established or created, I wouldn't say created, recognized a personal privacy right that many people would say is inherent. Yeah, I mean, there's a long list of Supreme Court cases that we could go over. I'm sure we will at some point. But yeah, judicial review, it's a really big deal. What is the check against judicial review? Right here.
In a constitutional amendment override.
Putting a constitutional amendment to override a Supreme Court ruling, that is one check against the judicial review. Spoiler alert, it's really hard to pass a constitutional amendment. It's really hard. It's almost impossible. Are there other checks against judicial review? Yeah. Passing other laws, you can do that. Sometimes the Supreme Court or other courts will say under current law, you can't do this because of X or Y. Congress could go back and pass another law. What else could Congress do to the courts to check the courts? Over here. Impeach justices, remove them from office. That's a way to do it. That is a check against judicial review. Hasn't been done much. Anybody else? Sabrina?
Court packing?
Court packing. They could add people to the Supreme Court. That's a thing that they could do. That's perfectly constitutional, been done before. Another thing that they could do is they could do what's called jurisdiction stripping, which sounds sexy, but is not at all. It is simply taking away the right of the judiciary to hear cases in a certain or about a certain subject. Could theoretically be done. The Congress could also defund the courts. If we want to get wacky, they could do all sorts of things. They just haven't, because Congress never does anything. All right, so that's the basics on judicial review.
All right. Let's see. Gonna screen share again. All right. So now I'm going to talk about what's called the incorporation doctrine. And I sent this in your materials via a link you can look at later. I know it's a little bit hard to see here, but I'll sort of go through it if you're not following along directly. So incorporation relates to this little amendment called the 14th Amendment. Has anyone heard of that? Yeah, cool. Someone tell me what's one thing that's in the 14th Amendment? Yeah. Due process. Great. And that's what we're going to talk about today. What's up? What else? Great. Equal protection. Anything else? Okay, nice. And there's one more that I'm looking for. Complicated. We'll talk about that, but yes, kind of. Is there any other, sort of phrase that you've maybe heard before? 14th Amendment. All right, the last one's called Privileges and Immunities Clause. So there's a bunch of stuff in the 14th Amendment. You should go read it many times throughout this. 14th Amendment is arguably the most important amendment in the Constitution. I think many people agree with that. And one of the many reasons why, is because it is the reason that the Bill of Rights is incorporated into the states. So what the heck does the Due Process Clause mean? There was not much debate in Congress about what it meant when the 14th Amendment was ratified. It's kind of a vague term. And courts sort of interpreting the 14th Amendment were faced with a couple of choices about how to interpret the phrase due process. The first one is for them to say, yeah, it means nothing. And the reason why that might be one of the options is because the Supreme Court basically said that in the slaughterhouse cases about the Privileges and Immunities Clause. The court in that case, when interpreting privileges and immunities, basically said that the 14th Amendment was only really meant to grant full equality to slaves. And thus, when they were interpreting the 14th Amendment, they were saying privileges and immunities clause was really limited to areas controlled by the federal government, and it didn't do much more beyond that. And so interpreting the due process clause, one of the options for courts was to say, yeah, just like the privileges and immunities clause, the due process clause doesn't mean anything. Another option is to interpret it to mean only the due process clause as it was written in the Fifth Amendment, which is one of the Bill of Rights, which has almost exact language the same as in the 14th Amendment. Another option is to mean that all of the Bill of Rights are incorporated to the states automatically. So right now, so in the Bill of Rights, it really only talks about Congress, what Congress can do. And so many people argued that when the 14th Amendment was passed, and it said, state may not deprive any person of life, liberty, or property without due process of law, they interpreted that phrase to mean that all of the Bill of Rights, which were widely considered to be liberties, would be enforced against the state. So states could not infringe on those Bill of Rights. And before the 14th Amendment passed, there was nothing restricting states to do that. So they argued that due process clause incorporated all of the Bill of Rights instantly. And what's the courts actually ended up adopting is something called selective incorporation, which is not quite full incorporation, but instead was this idea that some rights contained in the Bill of Rights would apply to the states, but it wouldn't happen automatically. So this created several years, decades and decades of this idea that the certain rights would be incorporated and protected from states while others would not. And so that's why we have this complicated chart here over the years, incorporating individual pieces of rights in any given Bill of Rights. So what rights are in the Bill of Rights? Someone want to raise your hand? Give me yeah, go ahead. Free speech, yes, important one. And that's in what amendment? Nice. Yeah. Right to trial by jury, good. Anyone else? Okay, great. Right to bear arms, sorry, I need to repeat them. Yep, no quartering of troops. Great. Freedom from excessive bail, yeah. Free exercise of religion. Go ahead. Yeah. Right to a fair trial. I think, yeah, go ahead. Yeah, self-incrimination, Fifth Amendment, good. Okay, yep. Unenumerated rights are reserved to the people. Go ahead, Ninth Amendment. Right to an attorney. Okay, great. Any others? No cruel and unusual punishment, good. No double jeopardy. Great, no double jeopardy. So that's a great starting off point for why I want to talk about this. The first selective incorporation case was Gitlow v. New York. It was a case involving socialist and revolutionary papers, and it incorporated First Amendment protection of free speech. However, in that case, it also upheld the conviction. So it's kind of an important reminder that just because we have the rights incorporated to the states doesn't mean that it's automatic and completely protected. These rights can still be eroded depending on and if you're in Unit 5 in particular, you'll learn this really well, that every right in the Bill of Rights sort of has a complicated test or theory to apply. But it just means that the states have to put proof to something in order to inhibit that right. So Gitlow v. New York was the first case to upload it. And then we had a couple more, as you can see, Stromberg v. California, Near v. Minnesota, for a little bit there. But at the time, the courts were sort of not really operating with any sort of standard. They just said, yeah, we're going to selectively incorporate it one by one, but we're not going to tell you how we're making this decision. And they didn't tell them until Palco v. Connecticut, 1937. That case was the first case where the court really articulated a standard for how it would decide whether or not to incorporate a right into and apply to the states. So in Palco v. Connecticut, it was a case, and this is not on the chart actually. It was a case where Palco was being tried for a second time for first-degree murder after initially being acquitted of first-degree and convicted of second-degree murder. And he tried to argue that the 14th Amendment applied to federal protection against double jeopardy to the states. And the Justice Cardozo held that only fundamental rights need to be incorporated into the 14th Amendment. And he went on to define these rights as of the very essence of a scheme of ordered liberty and rooted in the tradition and conscience of our people. So that was when the court formally introduced the idea of partial or selective incorporation. So from there, we have many other cases that happened after 1937, including right to assembly, right to petition, free exercise of religion, establishment of religion, notice to accused of the crimes against them, right to a public trial, no unreasonable searches and seizures. You can go down this list and you will learn more about these throughout the year. But this is a chart that's really handy for you to have throughout the year going forward. These are the kinds of facts you will be throwing into your testimony as you are answering questions. A judge will likely not ask, hey, is this right incorporated? But this is something that you can bring up in responding to questions about these rights to show off your knowledge. So this is going to be really important for you to learn down the road, especially for Unit 5, but for all of the units, in my opinion. There's only 3 real amendments that have not been selectively incorporated yet. First is the Third Amendment, freedom from quartering of troops during peacetime. That's the least used amendment out of all of the Bill of Rights. And so there hasn't really been an opportunity or potentially a need. There's a few cases that have tried to interpret it, see if it mattered, but they ultimately did not decide one way or the other. And the Supreme Court has not decided if it would be selectively incorporated. The Fifth Amendment also has not been incorporated, and that's the Fifth Amendment right to a grand jury. And that's interesting because then you'll notice that a lot of states don't actually use grand juries to charge these crimes as they go through. Did you want to add something? Yeah, exactly, like California. And so grand jury is a lot of times limited to the federal government, though there are some states that use grand juries. But yeah, that's not a right that's been incorporated. And then also the Seventh Amendment right to a jury trial in civil cases has not been incorporated. So many states will not necessarily allow you to by default have a trial in a civil case. Sometimes they have different rules set for whether or not it's appropriate for a civil trial to happen, but that has not been incorporated yet. So I want you all to talk about what are the problems, do you think, with the process of selective incorporation? Anyone have any ideas of what might be a problem with doing it selectively instead of maybe all at once? Yeah, Clint.
No one knows what's incorporated or not.
Yeah, that's right. No one knows what's incorporated or not. Is it written down anywhere in the Constitution? Selective, have you seen the word selective incorporation in the Constitution? I haven't either. That was just kind of full-fledged made up interpreting the due process clause. So that's one reason. It doesn't really have visibility and it's not in the Constitution. Can anyone think of any other reason why selective incorporation might be kind of bad? Maybe thinking about what I said about the standard with Palco. Go ahead.
The Bill of Rights is written to like automatically apply to everyone, but it shouldn't be up to the justice to decide which rights that are already like written should apply. Because I think they were all intended to apply to everyone.
Excellent. Yes, yeah. She said that it shouldn't be up to the justices to decide what rights apply or not. It should be automatic. But that's a huge reason. This standard seems to be allowing justices to decide what's important or what's not for our rights. And there are many rights on that board. How many people didn't have these important protections at the state level until 1968. You didn't have a right to a jury trial in criminal cases in state level. States are oftentimes the entity, especially in recent years, that are perpetuating infringing rights. And so that's super important. Great job. Anyone else have any ideas? Yeah, go ahead. Excellent. Yes, the Palco test is super squishy and it's really ambiguous about when to apply, and that interpretation can really change radically over time. And I did want to note that Dobbs v. Jackson Women's Health Organization, which is the case that recently overturned Roe v. Wade, which is the right to have a woman's right, people who get pregnant's right to have an abortion, cited Palco in deciding sort of whether or not this right was something that was traditionally or historically respected. And that's sort of a standard that the Supreme Court recently modified to fit its needs to overturn Roe v. Wade. And so it's really important taking this tradition of selective incorporation still has an effect today on how our rights are perceived. And although there's only 3 or so rights that have not been incorporated, this test is still very much relevant and could potentially lead to undoing of some of these rights down the road, depending on what the Supreme Court decides to do with this squishy test. So that's what I have for selective incorporation. Does anyone have any questions, or do any of my case volunteers have anything to add? Yeah, go ahead.
So the 9th and 10th amendments, have there been any cases where the 9th and 10th amendment have been tried to have been selectively incorporated?
Yeah, so the 10th Amendment is hard because it's not really a right that can be incorporated against the states. The 10th Amendment discusses federalism. It's a separation between the federal government and the state government, what rights the state governments maintain. And so that's not really a right that can be incorporated and enforced against the states. 9th Amendment's a little bit more complicated. As you may have seen with the Dobbs v. Jackson case, what the 9th Amendment means and does really depends. The Supreme Court has interpreted it to sort of mean that it needs to, the 9th Amendment creates a penumbra of rights. And so there hasn't been one case that I know of at least, that expressly incorporates the 9th Amendment to the states, but it has been sort of de facto through looking at other rights. So Roe v. Wade, for instance, did apply to states. That was a case that involved what state the state government can do or not. Yeah, anyone else have anything to add? Yeah, go ahead.
Question. How was selective incorporation decided? Because where's the Bill of Rights not automatically before 1945, before Bill of Rights in New York, were just citizens not entitled to the Bill of Rights? I'm thinking how that changed.
Excellent question. Bill of Rights, if you look at the text of the Bill of Rights, it talks about the federal government. It talks about what Congress can do. So those rights, and people read the Bill of Rights in different ways, but for most part, people consider the Bill of Rights sort of negative rights. It's what the government can or cannot do with those rights. And so Bill of Rights expressly was only about what the federal government could do. The founders weren't so worried about what state governments could do at the start of the founding. They were very much about states' rights. A lot of the Constitution is about the relationship between federal and state rights. And they thought because states are closer to the people, they would better reflect and respect what the people wanted for those states. But as we got after the Civil War and the 14th Amendment was passed, that was when the 14th Amendment is specifically about what the states can do. It's preventing the due process taken away from states. Go ahead. It depends. I think most of the rights that we have are in the Bill of Rights. There are some rights that are in the Constitution, and they sort of discuss whether or not they're federal or not. Does anyone else, do you know the answer to that question?
So the question is what's going on with the other rights in the Bill of Rights? or sorry,
Rights not
the other amendments. So the 13th, 14th, and 15th amendments specifically state that they limit power of states. After those amendments were ratified, like later amendments like the 19th Amendment, the 24th Amendment, I don't remember, the one about 18-year-olds being able to vote, they specifically delineate that they apply to states too. So there's not anything to incorporate, it's just the text applies them to the states.
Good question. Yeah.
Are you referring to like substantive due process in this case? Or are you referring to more so like other ways?
So selective incorporation is mostly about the Bill of Rights that are expressly listed in the Constitution. But you raise a good point. There's also in the due process clause, we fit a lot in the due process clause. There's also substantive and procedural due process rights. Procedural due process rights are sort of using the rights that we have, but also sort of melding it together with this idea of you can't be deprived of your life, liberty, or property without certain processes happening. So you get a trial, you get a jury, you get to be noticed of what you're being convicted of, you get the ability to have an attorney speak on your behalf. Those are procedural due process rights. But substantive due process rights are very much at the heart of what the Dobbs v. Jackson case and many others are about, which is what do we do with these rights that aren't in the Constitution, but are super important to us? And that's why I talked about how the Palco test is still used in the Dobbs v. Jackson case, is because the right to an abortion and the right to bodily autonomy and the right to privacy, these concepts are not expressly in the Constitution, but have been interpreted by courts, at least before this year, as sort of being part of the penumbra of rights that the Ninth Amendment gives us. That's what substantive rights are. And the court's most recent test in Dobbs v. Jackson says that it has to be sort of this historical, respectful, a right that's been historically referenced to and upheld in the past. But yeah, so substantive rights are also incorporated, and they're sort of incorporated by looking at the Ninth Amendment and these other rights. Yeah, cool. Any other questions? Okay, great. So I know we started a little late, so we're running a little late. I want to give everyone a chance to have a 10-minute break. So where are the restrooms if you need them?
So restrooms, if you walk to your left or your right, my left over there, and then another left in there, and then it's just, yeah, it's right in that little alleyway where you see the kind of water fountains there.
Great. Yeah, so feel free to talk amongst yourselves, and please be back at 11:15. That's in 10 minutes. And we'll be tuning in later via Zoom. All right, can everyone sit down and please be quiet so we can get started? All right, welcome back from the break. We are now going to be talking about CACE tips and tricks for a We the People program. So I'm gonna turn it over to Kate. You want to share screen? Yes, that's an excellent point. Thank you. And you all have it printed out in front of you, hopefully. You can also view it online. And please, people, feel free to chime in with other ideas as we go through it.
Okay, hi everyone. So several tips and tricks for a successful We the People team. Well, success is not guaranteed 100%. I bet this will help. So the first and most important thing is to consume 3 to 4 sources of news and current events per day. And that kind of sounds intimidating if you aren't reading the news regularly, but it can be done super easily, like listening to a podcast in the morning on your way to school or reading through like articles. It doesn't have to be as as intimidating as it might sound. But in terms of like news sources, some really great ones can be NPR podcasts, like the Morning Edition or Up First. Those are like 10 minutes or so and will pretty much cover the day's news. Miss Sklar. Yeah, we can zoom in. Does that help? Okay. And then, yeah, newspapers, if you still get one, that's great. My dad's a journalist, so he'll love that if you get newspapers. And then other podcasts that might be helpful for like specific We the People content. We the People, the podcast by the National Constitution Center, is great. It's nonpartisan, chartered by Congress. You'll hear that in every tagline of their podcast, but they're super helpful for breaking down like any current cases before this court or other like issues relevant in the world of politics. And then another one that's really great is which one was it? It was there's Miss Sklar, I think you told us about one with that went over the different amendments. Do you remember which one? It was More Perfect. Yes, it was. That's a really great one. They go through each amendment in the Bill of Rights really in depth, and they make them fun and interesting too. So would recommend listening to those. And then another important thing for the second point is outlining your testimonies before you write them. Testimonies are also pretty intimidating, so it's always helpful to have like a brainstorm session within your unit, talking to alums and then getting into outlining each different part of the question. And so the most important part of your testimony is really your thesis and how you're going to approach each portion of the question. And you can do this by working in teams, either like verbally and writing it out on a Google Doc. So that's really helpful. And then with an outline, you can really go towards alums or other units and kind of bounce back ideas. It's a really great way to make this like really overwhelming task a little bit more simple. Third is debating your position on the issues with your teammates before, during, and after you write your testimonies. So most of these questions that you're going to be dealing with are a lot of matters of opinion. And so being able to have some background knowledge on the topic is really important. And that way you can kind of discuss your own opinions with your unit and bounce back and forth who is agreeing with which part of the question. And that might shape how you structure your testimony as well. And then it's okay to disagree. That actually makes for a really good conversation and a really interesting testimony from a judge's perspective. You want to have like a nice dialogue that can continue on in Q&A. Fourth is getting feedback on your testimonies and Q&As from as many people as you can. This is huge because you want a lot of different people to read through and make sure that everything you're saying, it might sound good to you, but to another person, it might be really confusing. And so fleshing out those ideas is helpful when you talk to a lot of people. So like, again, this can be other units, or it can be alums from previous years. One thing that was really helpful that I would recommend like each of your teams do is we had a whiteboard that was like a grid of each unit and then different alums, and we would check off or tally mark whenever that unit would reach out to like Gowrie or whoever. And then it's kind of a competition. You want to like make it more fun, and it's a great way to get a lot of people involved and also just have like a nice visualization of what you're doing each week as a benchmark. So that's helpful. And then of course, like Discord, I think you guys are all available and we'll always help out reading over testimonies. So yeah, and then take advantage of like at Amador, at least Mr. Weaver, Ms. Wolgemuth, everyone will help and is really willing, which is nice. And like I said, ask for help and use your available resources. So like teachers, alumni, CACE. Yeah, don't be intimidated. Everyone really wants to help and it should be a nice, fun experience. 6 is that good teams can identify problems, but great teams will identify solutions. So in testimony, you're often going to be discussing different problems across different branches and political spheres. And it's great to identify them, but in order to really come across with a nuanced argument is to bring up a solution. And so a lot of the times, at least in my unit, we would look towards different law review articles that might mention the problem, and oftentimes they have solutions that are recommended by various professors. And so you can get ideas from that as a solution. I know you're not probably going to solve like all of these problems, but being able to identify solutions that aptly tailored to these problems is really interesting for judges to hear and can show, like, demonstrate your knowledge in a really strong way. Number 7 is practice arguing the other side of every position that you take. So learning the counter arguments is really important because oftentimes if you're coming in strong in Q&A or testimony with one opinion, then judges will ask, like, bring up a counter argument. And so you want to know those sides and be prepared and have evidence for the other side too, and then present your own side in a way that suggests it's more strong. And so this can be really helpful if you are even splitting up with your units, whether it's 2 versus 1 or like 2 and 2. Each person is like answering and asking Q&A. That way it's a really dynamic conversation you can do just within your own unit. Like, you don't need to be in front of the whole team. So that's a great way to develop those understandings of different sides of the argument. And then 8th is working with other units in your class. So each unit has sister units. I think it's 1 and 6, 2 and 4, and 3 and 5. And so once you're all in units, it'll be great to meet up with your sister unit and talk about oftentimes what's helpful out of sister units is evidence. Like, you can kind of share evidence and bring up different issues like philosophy and current events. Like, you wouldn't really think to connect those, but oftentimes having those conversations, you'll be able to see how you can kind of blend the information across units. And then finally is spend non-We the People related time with your unit. And so it's kind of a given, you're going to spend a lot of time with your unit, and it can be a little stressful and high energy, but getting to know each other really will help things flow and give your unit cohesion. And that translates not just in your working environment when you're practicing and preparing, but also when you're actually presenting and having these conversations. You want to know how the person next to you is going to respond. Like, you're going to know these people really well. And so having time outside of We the People with them, whether it's getting dinner or like going on a hike, doing something together, will help build that cohesion. And you get really close to your unit. So even if you don't think you're going to mesh that well, I guarantee, like, spending time like this is also a really helpful way to build those relationships.
Yeah. Great. So I just wanted to add, go ahead.
For the asking for help with teachers, what specifically would you ask them, like, for evidence or like an idea?
I think it's helpful to get time presenting. So you could ask, like, would you watch this testimony and give us feedback? Or would you help us edit this testimony? Does this sound right? Even practicing Q&A with them on a more one-on-one basis can be really helpful, because they'll often be able to target feedback and give you a lot of their feedback rather than in like the time crunch that is a practice during class.
And also,
Wait, really quick. And the question was, what do you do to ask for a teacher for help? So now Sean has something.
Yeah, something I've also seen a lot with, I'll step over. Something I've also seen a lot with what teachers do is help you decide if something's a good piece of evidence. You can ask, other volunteers for that too, but I know the teachers often have a lot to say about that. So I've heard over the years, a lot of students will go and say, is Brown versus Board of Education a good piece of evidence to use for this particular bullet point of our, prompt? So I see that as one of the main things you could quickly get an answer from your teacher in class.
Before we take more questions, did anyone else have thoughts?
I think Mr. McBride, he saw raising his hand in the back to kind of get at this, but if you go to Foothill as well, one other thing you can get from your teachers that can be really helpful is specific, like, kind of topic guides or overviews of a certain really confusing topic. So once you start getting into like your state's questions and you've got these kind of really core issues you're looking at, like substantive due process or thick rule of law, things like that, that are kind of more scholarly and hard to understand, your teachers have a basis on what these ideas are, and they can be really helpful to give you presentations and kind of give you like a starting point to how to research these topics. So that's another really good thing that your teachers can be helpful for.
if I could just back on real quick. Yes, I appreciate that. CACE has a Discord, right?
Yes.
Yeah, so that was what I was going to talk about really quick.
Sure. Well,
Go
I
ahead.
just wanted to ask, yes, we don't talk about the details of it, but one of the things that is so common, one of the things I love about these people as a coach is that when we get to like high level competition stuff, there's no perfect answer, really. There's no perfect way of writing testimony. Oftentimes I'll be having conversations with units and they'll be like, oh, the structure of the testimony and what should we do with it? Is this good? And I'll be like, I don't know. I think it's pretty good, but maybe there's another way to approach it. Like, I don't have a perfect answer. And the amount of times I've told students, hey, why don't you send me testimony on the case, see what their feedback is, and see what bounce back. And the amount of times the students have not done that after we've asked them to is astounding. The amount of like communication channels between this group and CACE that is not used is unfortunate. Because no one in this room is being paid. We do this lightly, and CACE their self as we talked about throughout the entire year. So take advantage. I'm sorry.
Well,
No,
let me.
Wait, sorry, really quick. Just to summarize what Mr. McBride said, because the recording might not been able to catch it, is oftentimes there is no right answer in We the People, and it's really helpful to use us as a resource. And as I flagged a couple of times, we will set up a Discord for each of your schools and each of your units within your schools, and we also have a CACE general Discord where we will be sending you periodically news articles we come across that we think that you would find interesting, podcasts, that sort of thing, relevant to the questions you're dealing with, and will be accessible throughout the year. That's the best way to contact us, and we will set it up per school shortly after you get into your units sorted. And that is the best way to contact us. Instead of individually messaging us on Discord, please just do @CACE volunteer, and I'll send the instructions in an email. But all of us have full-time jobs as well, so the fastest way you can get feedback from us on testimony or a quick question more substantively is to kind of all of us, and that way we'll get back to you faster. And we'll do our best in that regard. Yes, Sklar. Ms. Sklar.
On that same note, because there is often no one answer to a lot of these questions, I think that the kind of design questions so that there's multiple people for you. You will find that you often get conflicting advice from different members of the case, for example. We might love your introduction to testimony, and Mr. Woods might hate it, and hate it, and really get to that email all the line. And so you really have to know enough about the topic. They need to make a judgment call, decide which way you want to go, even though someone might not like it at some level.
Yes.
Yeah, that goes doubly for photo between Dedmore and myself. You will find that we will have the opposite advice sometimes. Like that, one thing I tell you another thing, like CACE is a great medium.
Yes, just to repeat what's been being discussed in the room, it's really great that you have a bunch of different people to ask questions about because there are no right answers. And oftentimes, if you get conflicting information, you should do what you think is best. Again, if Mr. Woods says, I cannot stand your introduction, but you love the introduction and you've gotten feedback from others that they love the introduction, and keep the introduction. It's really up to you. This program is about you developing the writing and oral advocacy skills that you think will help build this. It's all about you. We're not going to tell you write it this way or speak it this way. We're going to give you the feedback we have from our experiences, and you're going to take what you can and what you think is right and apply that to the competition. And that's the best way you'll succeed. Okay. Yes, Sean.
So the other thing I can say to encourage you to reach out to us is and utilize cases that many of us either have or will be judges for the various competitions throughout the year. And so if you're wondering what will the judges think about this, some of us have done that or will do that this year. So take advantage of that. Where obviously there's judges from all over the state who will see you at the state competition, but we can still give you a pretty good insight into like how the judges might analyze your testimony. It is a competition. It's also a learning experience. So, it's both things in this program, but, don't, to Mr. McBride's point, don't be told to reach out to us and encourage to do that. And then, not reach out to us if it's a good use of your time.
And don't wait for the last minute. Once you're assigned to a unit, they help that unit or the conflict of interest. But if you were pushed on the wall and early on, maybe you didn't shout before you were assigned to judges, maybe they need to do that before they were assigned. So it's good to kind of get a jump on it. And, you obviously you're watching the best push early, but don't procrastinate.
Yeah, as Ms. Sklar said, don't procrastinate in contacting us because as we go through the judging season, certain of us will be assigned units and will not be able to help you on the units that were assigned, but we'll be able to do it beforehand. Also, please don't try and, send us a testimony at 9 p.m. the night before a case practice because you want our feedback to edit your testimony. That's just not reasonable for us to be able to help you out. So try and give us some lead time beforehand. I know you're constantly revising, and that's one of the things about this program. You are constantly going to be revising your testimony, sometimes even 2 days before the competition. That's normal. That happens. You will not write the perfect testimony. You will not write the perfect testimony the second time around or the third time around. And so keep that in mind and just know that it's like an evolving process. Please come on up.
Yeah, I just wanted to emphasize, two things that, they're on this list, but I think are really important. And the first was, really acquainting yourself with, multiple sources of news on a daily basis. Even if that is just, reading, just, the big main articles for a day or something. Or really getting into it. Like I used to read a lot of Politico when I was in We the People, just because I was a Unit 4 guy, and that gives a lot of insight into Congress and the Hill on just a daily basis. And the other thing was spend time with your unit, hanging out, just having fun, become friends with them, because having chemistry as a unit is so much more important than you realize. It just helps elevate your testimony and your Q&A to where you guys are building off of each other more instinctually without having to think about it and plan these things. You guys just kind of know each other because you're friends and you're having fun and you're hanging out, just, I don't know, going to downtown after school or whatever you do. I don't know. But yeah, that's what I want to emphasize.
Yeah, I think the thing I would say is that having seen a lot of teams over an entire year is that I think the three skills that CACE really relies on, or We the People relies on, are research, kind of logic and reasoning, and the third is communication. And I tend to find that like for the regional local competition, or at least this kind of like first phase of competition, a lot of you are like focused on research questions. It's like, what is the rule for this? What is the case for this? Because like you just haven't had the time to dig in at that level. And I'll say like up front, like that's probably like the least exciting part of it. But like the faster you can do that research, the faster you can like structure it out and say who's reading what things do we all have to read, the faster you can move to a point where you're thinking about, okay, well, like how do we answer this question given what we know about the issue? And like the questions in the regional and the state competition, like do this on purpose. So you'll find like locally, the questions are like, what are the three, what like the things you can like research and then like answer probably like correctly more or less. Whereas like as you move into state and nationals, like you're right, there is no correct answer. It's about both like what reasoning you use and then how you communicate it. So as you move from like state to nationals, a lot of it is asking folks like us, folks like your coaches, like what will land well with the judge, or how do we communicate it in a way that will land well with the judge? And so my advice to you all would be like to do this research part really well, because it gives you a great foundation for doing the way more fun stuff. And then the other thing is to practice things like communication even now. So as you're thinking about, how to share with your teammates or share across units, like you're not used to like talking about this kind of, at least I wasn't, right, in the way that, you talk about other stuff in life with your friends. Like it's like a very new sensation to be like, this piece of evidence suggests this, and thus I think this. And the more you can practice saying it like that, by the time you get to March, April, May, you're not going to be worried about, oh, how do I keep my answers down? How do I fit in all this information? Because you're used to talking about it kind of in the way that these folks are, because we've been doing it for years and years and years. So I know it's a long ways off for like here to the end of the year, but the more I can see, I guess, like those skills, the more we can think about using them, I think you'll do really well.
Yeah, So really quick on the sources, I think Sahil reminded me a really good point, is that you want to have balanced viewpoints, right? I think a lot of us, being in the Bay Area, being in California, we're really, really progressive, which I think is a great thing. But then also you got to be able to know how, the other side is arguing, right? So you may not like it, but, taking a look at Fox News once in a while, just to know what they're saying I think is important. But kind of more conservative, like leaning media sources, I would really, really recommend. Christian Science Monitor, The Economist, and sometimes The Atlantic has really interesting opinion pieces that come from more conservative viewpoints. And so I used to be a congressional researcher on the Hill, and we used to write reports that were legally required to present both sides of every argument, right? So look up the Congressional Research Service, right? They do really, really good policy reports. Also, the Government Accountability Office, GAO, they also do really, really good work, and the Congressional Budget Office. So that's usually the one that you hear in the news about, oh, what's the tax implications of Biden's new budget proposals. So put those out there, hopefully use them.
Anyone else have anything to add? All right, and once we get the Discord up and going, we'll probably compile a list of sources that we like to look at, including podcasts and stuff. So if we didn't mention it here, we can give sort of a more comprehensive list going forward. But just really quick, the important thing is not just your sources. You'll be researching the answer to specific questions, but really knowing what's going on in the news at any given point is critical to this organization, because judges will sometimes look at the news and just look at the headlines going into a competition and say, oh, I wonder how this applies to their question. And that will be the basis of the questions they're asking. So even if you studied everything before that point, you're not necessarily going to be aware of what's going on in the news. Well, it's important that you stay aware. And a lot of times judges will creatively put together sort of information from the headlines. So start doing it now. Start looking at news sources now, and you will feel very informed on what's going on in the world. It's really important, this competition. All right, great. Any questions? We've covered a lot. I know a lot of it's sort of more in the abstract. As we go through this competition, you'll learn how to apply it sort of more going forward. And we're not going away. You have the tips and tricks in front of you, but we'll also constantly be able to ask us questions about the format of the competition, in addition to the substance of what you're doing. Any questions? Okay, great. So now we are going to move on to the breakout sessions. We're going to be answering the question, what is the most important Bill of Rights and why? We're going to break out into 9 groups in person, and we're going to have one group via Zoom. So Harsha, I'm going to send you and everyone into a breakout room right now. Can somebody do a count off for the 9 people?
And just so I know, the question is what is the most important right in the Bill of Rights?
Correct. What's
Okay.
the most important right in the Bill of Rights? Not what is the most important Bill of Rights.
Okay, so what is the most important right in the Bill of Rights? There are lots of amendments that have multiple rights. Okay, so what we're going to do here is I'm going to do a count off. If you 1 through 9, everybody's going to have to remember your number. This is hard, right? I'm not a math person, but remember